Welcome to our exploration of private international law, a pivotal field in today's interconnected world. This branch of law, often referred to as conflict of laws, is essential in resolving legal disputes that span across multiple countries. Today we'll delve into its definition, key functions, historical development, and its relevance in our globalized society. Private international law primarily addresses three core functions: jurisdiction, choice of law, and the recognition and enforcement of foreign judgments. Jurisdiction determines which country's courts have the authority to hear a case. Choice of law decides which country's laws should apply in a cross-border dispute. Lastly, the recognition and enforcement of foreign judgments establish whether a judgment made in one country can be recognized and enforced in another. The historical roots of private international law are both ancient and rich. Initially, it was an informal system driven by customs and agreements among merchants. In ancient Greece and Rome, traders operated under basic rules facilitating cross-border transactions. During the medieval period, the lex mercatoria, or merchant law, emerged as a set of commercial laws used by merchants across Europe. As we moved into the early modern period, European nations expanded their empires and trade networks, necessitating a more organized legal framework to resolve disputes related to contracts, property rights, and maritime law. Scholars like John Westlake and Joseph Story played significant roles in formalizing these principles. The 19th century marked the birth of modern private international law, with the codification of laws and the rise of nation-states. The Hague Conference began developing treaties to regulate this field, focusing on areas such as family law and international sales. In the 20th century, international cooperation became crucial. The Hague Conference on Private International Law emerged as a key body for harmonizing legal principles globally. Post-World War II, international organizations like the United Nations and the European Union influenced its development significantly. Today, globalization and digital communication present new challenges. With business and personal relationships increasingly crossing borders, legal systems must adapt. Technological advances like e-commerce and multinational companies have led to more cross-border legal issues, prompting the evolution of international treaties and conventions. In conclusion, private international law has evolved over centuries to address the complexities of international relations and commerce. It provides order and predictability in managing cross-border legal relationships and continues to adapt as globalization accelerates. As we face new challenges in this global era, understanding private international law becomes increasingly vital for navigating the legal intricacies of our interconnected world.